unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Welcome to the show. Today we're talking about creative financing, graduate level creative financing. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like. You can find us on YouTube. You can find us on Facebook, and you can find us on Twitter. We are at INREM Podcast. That is at INREM Podcast. With that, I'm going to turn it over to Sean, who has our legal update.
Thank you, Andy. So our legal update today continues with my what if questions I've been throwing out there. So today, my what if question is, what if a buyer under a purchase contract with a close of escrow date fast approaching, let me try this again. I've kind of butchered the question. All right. What if you are a buyer under a purchase contract with a close of escrow date fast approaching, but the seller has ghosted you in the title company or the closing attorney? That's much better. Okay, now let's get started. So, okay, you're a buyer, you're wanting to close on a property, and all of a sudden the seller is nowhere to be found. They're not communicating with you or the escrow company. What do you do? Well, in that case, it really is going to depend upon the terms of the contract. So first, you need to know, does the purchase contract have a cure notice or not? If it has a cure notice, then you as the buyer should put yourself in a position to close escrow and then send the seller a notice that they're in breach by failing to close escrow on or before the close of escrow date. So you put yourself in a position to close, you deliver funds to the title, you request the title put together all the documents necessary to be executed, and then you send a notice to the seller when the close of escrow date comes and goes, basically notifying the seller that they're in default. Alternatively, you could, because there is a cure notice, you could wait and not do anything for a short period of time. But here's the but. If the seller wakes up and comes back and is like, hey, buyer, you didn't do anything to close escrow, it's time for you to close, and they issue you a cure notice, you're going to have to scramble around, and you better cure within the time period. So a lot of contracts in Arizona have 3-day cure notices. The contracts I draft for my clients have 10-day cure notices, which is a little bit longer, but a 3-day cure notice is a very short amount of time and generally doesn't include weekends or holidays. And so, you're scrambling around trying to close this thing. And if the cure notice was sent out on, say, a Friday, you're talking maybe one business day to be able to close this thing as the buyer. So that's why I say I not wait to put your ducks in order. I would go ahead and be in a position ready to close on or before the close of escrow date. So if the seller, does issue you the cure notice, you're ready to go. Now, what if the contract doesn't have a cure notice? If the contract doesn't have a cure notice, then in that case, you as the buyer better be able to show that you were ready, willing, and able to close escrow on or before the close of escrow date. So what that means is you communicate to title, you say, hey, title, put together the settlement statement, put together the all of the documents that I as the buyer need to sign to close escrow, give me the wire instructions, and you basically deposit on or before the close of escrow date all of the funds necessary to close. you execute anything that you as the buyer are required to execute to close escrow. And then you likely will want to send a demand letter to seller, letting them know that you are ready, willing, able to close, and that they've failed to, and that they're in breach of the contract. And then from there, you need to basically take steps to file a lawsuit for specific performance, and record a notice of lis pendens so that the world knows that you're seeking to hold the seller to their contract and require them to perform. So hopefully that answers the question of what if you as the buyer are under a contract and you're trying to close escrow, but the seller has now ghosted you in the title company. It depends upon whether or not your purchase contract has a cure notice. And depending on those provisions, you need to take steps potentially to show that you are ready, willing, and able to close escrow on or before the close of escrow date.
All right. Thank you, Sean. With that, let's talk about some in-rem announcements, upcoming events. Today, our topic is creative finance, and that's a good segue into our Creative Finance Collective, which we hold every Wednesday evening at 5 o'clock Arizona time. So what is the Collective? Collective is just a group, a membership of professionals, attorneys from all over the country who spend time in creative finance, who approach creative finance from different perspectives, from different jurisdictions, under different laws. And it's an opportunity for us to come together, talk through it, talk about it in a casual setting, but more importantly, an opportunity for you, the listener, the real estate investor, or maybe aspiring creative finance kind of attorney that wants to get into this, to ask questions. We make ourselves available the entire hour of the show. All of the attorneys that participate are there to answer and discuss questions. And sometimes those questions are good segues and jumping off points into a new discussion. It's really, there's no outline as part of the program. It's really just freewheeling and discussing all things creative finance. Sean, I thought the last episode went really well. What did you think about it?
Yeah, I mean, it was tremendous. You know, for me, like, audience participation is great. And, we're doing this, for the audience a little bit. But at the end of the day, man, the idea that we can sit around with other attorneys in the creative finance space with tremendous knowledge and just discuss these topics. I mean, last week we had Jeff Watson, Scott Horn, Alan Seschker, Elizabeth Best, you and myself on, all basically just sitting around, discussing creative finance. We had, campfire stories with Scott Horn, as he told us a bunch of war stories, which were awesome, and, got the conversation going. It was just a great time to network with other attorneys within this space. And then the audience has a front row seat to that discussion, where we're bantering about, these different issues. Last week, and frankly, you and I kind of come up with a few topics like, hey, maybe we should throw this out there, whatever. Last week, I think, hit on one of our 3 or 4 topics. We mainly focused on, how to properly, prepare assignments. And then we talked on, recording memorandums of purchase contract. And we shared, different statutes in the respective states that we're licensed in. And I will say, if you're in the, audience today, or watching the show at some point, and you're not tuning into the collective, I mean, you're missing out on these nuggets of wisdom and knowledge from, frankly, in my view, some of the best attorneys in this space, who just have tremendous reputations, have been doing it for long periods of time, a lot longer than the fads that are out there, right? I mean, the creative finance is kind of becoming the new, hip thing. But, these attorneys have been doing it long before that. I mean, they've been doing it, for decades, some of them. And so it's pretty awesome to be part of it, to be able to, pick the brain of these attorneys and just to gain the knowledge for me in my own practice, frankly.
Yeah, it's really a neat opportunity, and it's worth mentioning and reminding. You wouldn't be able to walk into any one of these lawyers' offices for an hour of their time for less than probably $500, right? I mean, that's the
Right.
reality of it. That's what we do as attorneys, charge for our time and what we know about particular matters. This is just really a neat opportunity for you to engage in a really different way with those that are doing it. All right. Also, a reminder today, we are available and live, obviously, for live questions. So if you have a question to pose to us today, we're going to get to the questions in the last 15 minutes of the show. But if you've got a question at the top of your head now and you want to pose that, go ahead and put it in the chat. We're still going to hit it, and we'll get to it in order of priority as they come in. So feel free to post those there. We appreciate it. We're watching, and we'll do our best to answer those. With that, we're going to get into our topic today, and we are talking about creative financing, and we're going to assume in this episode we're not going to talk about the straight up basics of creative finance. We've done that. You can see some of our episodes about that. If you've got a question about it, certainly ask the question. We'll address it. But we're assuming some basis of knowledge here, and we're kind of taking this to the next level, and that's what we mean by graduate level. And with us to discuss the creative financing is our old friend in Colorado, Bill Bronchick. Bill, how are you? Thanks for joining us.
Great to be here. Thanks, guys.
Yeah, appreciate having you. So for those of the audience that haven't or are not familiar with Bill, why don't you tell our audience how you got into what you're doing and what it is that you do?
Yeah, I've been a practicing attorney for 32 years, primarily in real estate, and in real estate, primarily in the realm of creative finance. I also do some estate planning, mostly for my real estate investor clients who have complex, large estates that they want to leave to their kids without hassle, and God forbid have their children sell it all off and ruin it. And also I do a lot of entities and asset protection and tax planning for clients. So that's pretty much my realm. I've been an investor as well for 30 years, done everything that you can imagine, except a car wash. I always wanted to own a car wash. It's the only thing I haven't owned. I've owned commercial, residential, multifamily, self-storage, industrial, mobile home parks. I always wanted to buy one of those things where you put the quarters in and it goes beep, 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 beep. And then you rush to get done and then switch it out with a swipe card. So you're like, la, 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 talking on your phone for 15 minutes, racking up the charges. So, but that's been my realm. You know, I've written 6 published books. I do teach seminars on this, and for many years I ran one of the largest real estate investor associations in America, the Colorado Association of Real Estate Investors.
So we'll get into the details here on creative finance. I'm curious though, you've got a lengthy background in history and in creative finance and real estate investing, and as a real estate attorney. Did you ever see a time, just kind of thinking back, where seller financing or creative type financing had the same kind of hype that it seems to have now?
No. I'm getting calls from real estate agents every day of the week saying, teach my staff how to do this because my seller won't drop his price. And I think we can get him his price if he's willing to do terms, but we don't understand that. So,
yeah. And I think Sean, you probably agree with this. We've seen over the years of practice the times where we'll do a wrap transaction for somebody or a seller finance transaction, but I certainly can't remember a time where creative financing had this kind of hype that it had before. Sean, have you ever seen that?
No, and to Bill's point, I mean, I'm off teaching CE courses to real estate, agents and to realtor associations. I have one coming up in September to a realtor association up north on creative finance and wraps and seller carryback. And frankly, to Bill's point, sellers may be able to obtain their asking price if they're willing to also allow that 3% loan to remain in place. And when those in the industry start fully appreciating that, I think we're going to start seeing more movement of buying and selling properties because, I personally have a property that has, a low interest rate. And, I don't want to go and sell that and give up that low interest rate and go buy a property at 6 or 7%, right? Why would you do that? So people aren't selling. But if they know that they can sell, and then maybe jump into some, maybe we're going to see more movement in the market.
Yeah. Yeah, we've discussed this idea that the sellers ought to start seeing the loan that they have with their mortgage as an asset and something that is something buyers are going to want and they can use as leverage maybe to get that price. They just have to be willing to play ball. So let's start here, Bill, and talk about what are some of the biggest mistakes that you see people that want to get into creative finance are doing? What are some of the biggest mistakes they're making?
Well, first, they're penny wise and pound foolish when it comes to legal advice and forms. So they go to, Joe the Guru, who probably doesn't know that much about real estate, but he's a good marketer. Pay him $10,000, and they say, "Well, you should go to a lawyer in your state." And they come to me and say, "Well, I need some forms." And I said, "Well, I don't sell my forms. If you want to hire me for a transaction, this is the fee." And they go, "Well, I just want the forms." I'm like, "No, I don't do that." It's like giving the keys over to a car without a driver's license. You got to know how to fill out the form. I don't give them out to brokers either. So I think the mistake is, you're dealing with 3, 4, 5, depending on where you are, $600,000 assets, and saying, "Well, I don't want to pay a few grand to an attorney, but I'm willing to pay a broker fee of 15 grand, but I'm not willing to pay an attorney a few grand to look this over or draft the contract or advise me on the pitfalls."
Yeah, forms are obviously a big problem. And what I think becomes part of that is we kind of sink to our lowest common denominator as humans as well as investors. And any way to save money is oftentimes what somebody will do. So what is easy and cheap to do? And that's get a free form on the internet and just cross your fingers and hope it's gonna
Sure.
cover you.
Sure. And some of those websites that say they're state specific, so they insert, "This is governed by the laws of," and they plug in that state. That's all. They're not really state specific. And every state has their own little, intricacies involved, especially when you're dealing with people who are behind in mortgage payments. You got foreclosure protection acts. In my state, they amended it to say it applies to if you're one payment in default, no notice of default filed, no list pendants filed. You have to comply with the foreclosure protection rules, which is rights of rescission, specific disclosures, certain font point size, and all kinds of documents and disclosures. And most people just don't know that. They never heard of that.
Yeah, let's talk about that a little bit because here in Arizona, we have some foreclosure rescue laws, but not to the extent of Colorado's. Yeah. And I think Colorado, maybe Washington, Oregon have very similar foreclosure protection laws. So talk to us about that, because I think that's where a lot of these, investors are really going to make mistakes is they get a form and then they decide, oh, well, I can use it everywhere because a purchase contract's a purchase contract. Right. It doesn't work that way. And I know it doesn't work that way in Colorado. No. So talk to us, if somebody's 30 days late on a mortgage payment and you're going to go in and you're going to do a subject to transaction, what are the things in Colorado that have to be in that purchase contract?
Yeah, so you have to have at least 12-point font size. Can you imagine? What are you in for? Armed robbery. What are you in for? Font. criminal violation of the statute. So it's got to be like a 12-point font. And thankfully, the state Department of Real Estate Commission has a foreclosure form, specifically for those types of transactions. It has the disclosures, and you got to give them the right of rescission. And people think it's 3 days. It's not. It's midnight, the third business day following the day you signed it, which is, it's hard to calculate if you have to read it a few times to figure that one out.
Well, and if I remember correctly, you can't just say that. You have to actually calculate for the sellers.
It's because I've lobbied this whole thing, and I wrote about a third of the statute when I was president of my RIA, to help out investors. Originally, they wanted a 10-day rescission, which is absurd. And they wanted no subject tos in foreclosures, which was absurd too. So I said, let me write a disclosure, so we can do subject to. So we have to put that in. You have to give them a right of rescission form that says, I wish to rescind. And I go beyond that too with people and because the problem is you can rescind orally. You don't have to use the form. So what if someone calls you up after day 2 and says, I don't know about this. Is that a rescission? Do you need a new contract? The thing is, You don't know. So I make people sign after the 3 days are up and they haven't rescinded them, make them sign an affidavit that says 3 days have expired and I have not rescinded at any time. So they can't come back later and say, I called them.
Right.
Right. So you got that. And then just a bunch of, my own disclosures of things that I put in there, such as, it's going to remain in the seller's name and it's going to remain on your credit report. It's going to affect your ability to get a new loan, your VA eligibility if it's a VA loan, et cetera, et cetera. And then we have rules about sale lease back with an option, which I always think is a terrible idea anyway. So if you want to buy subject to and sell it back to the owner on a lease with option to repurchase it, there's all kinds of rules regarding that I wrote. I just tell clients, just don't do them.
Right.
If they're in default, you're setting them up for failure.
Well, let me ask about the Foreclosure Protection Act, and I'm knowledgeable about it, and just because I'm in this space, and so I kind of keep up on this kind of stuff, but I don't know the ins and outs, obviously, like you do. Is there a structure where you could basically acquire either possession or an interest in the real estate subject to, without having to worry about or comply with the foreclosure protection law? A lease option might be an example of what I was kind of thinking about, but I don't know.
Well, a lease is not a purchase, and an option is
right.
property right. So you would, but I don't think I would want a lease option with someone in default of payments. I would want the deed and make up the back payments and get it subject to. Unless it was like one payment, maybe. I've done that a few times. But if someone's 9 payments behind, they better have a lot of equity for me to want to do an option. It's too risky on the buyer's side, because if the seller, as you know, the seller files foreclosure, the trustee in bankruptcy can cancel that executory contract and you're out of luck. It happened to me once. I lease optioned a property from somebody, sublet it to somebody to live in with an option to buy from me. The option to buy from me was higher than the option I got from the owner. And 6 months later, the seller files for bankruptcy. And the trustee in bankruptcy canceled my lease option, which he has the right to do.
Right.
It's what's called an executory or unfinished contract. So,
right. Yeah, exactly.
If I had just gotten the deed, that's a completed transaction, and they couldn't cancel that. So yeah, that's a risk of doing a lease option with someone who's in default, because if they're in default of mortgage, likely they're in default of credit cards and car payments, and they may end up in this Chapter 7. So it's risky.
Yeah, great point. What about a contract for deed or agreement for sale, as we call it here in Arizona?
Right.
Would that fall under the Foreclosure Protection Act in Colorado?
Yes, that's considered a sale. So it would require and the same problem I have with that, if someone's in 9 payments in default and they're facing potential Chapter 7, an installment land contract or contract for deed is an executory contract, and you can cancel it and you're out of luck. If I'm just going to acquire it to rent it, okay, I'll take that risk. But if I'm reselling it on a wrap, I'm putting myself in a precarious situation if that seller files bankruptcy.
Bill, with hype, oftentimes with governments comes more regulation. So what are you hearing on the ground in Colorado? With the hype of creative finance, is there any other potential regulations that they're looking at or that might be coming down the pipeline?
Not here. There's been 2 or 3 states that have passed laws requiring people who do contract assignments, for example, to be licensed as a real estate agent, which is not a big deal. I don't think that's the worst thing in the world, because it's going to weed out 80% of your competition who won't take 3 weeks to study online and pass an exam. It's not that big of a deal. North Carolina in particular tried to do this whole, there was an assistant attorney general there was on the warpath on real estate investors and tried to ban subject tos and lease options or just regulate them out of existence, and it never passed, thankfully. But they did get something passed that had certain disclosures that had to be in there, which are non-problematic. Texas is the big one. Texas virtually outlawed the lease option and contract for deed
Right.
by saying anything more than 6 months, which is, as a practical matter, useless if it's less than 6 months, has to have so many requirements and disclosures and permission of the underlying lender. And if you violate it, it's a $200 a day penalty. So, you don't want to go there. 3 years later, someone cancels and it wants, about 1,000 days at $200 a day. That's a bad penalty. So they've effectively outlawed contract for deeds and lease options to an owner occupant. Now, you can buy on one if you're an investor. You're not an owner occupant. But if you're going to sell to someone as an owner occupant on a lease option or contract for deed in Texas, it's almost impossible to do. Not impossible, but pretty ill-advised. So in Texas, they just do the regular old all-inclusive trust deed, wraparound, where you deed it over and take back a wraparound second. And it's okay because the foreclosure process in Texas, if your buyer defaults, is like 31 minutes. I'm exaggerating a little bit. It's about 40 days.
Right.
To foreclose someone in Texas, So, in Texas, they hang them high and foreclose them quick. So it's not a big deal to get the deed subject to with a wraparound and sell it that way too, because you can get it back pretty quick. Whereas like in my state, in your state, it's months and months and months.
Yeah, we're 91 days for a foreclosure here in Arizona. Which isn't horrible compared to some states that are, mortgage states where you have to file a lawsuit.
Florida or New York. Yeah, because New York could be a year.
Right. Yeah.
But, as I'm sure you advise clients too, if someone defaults, you'd say, okay, you put 40 grand down. How about I give you 10 back and you're out by next Friday?
Right. Yeah. You can do the deed in lieu and that type of thing, as long as title's clean. But so you already kind of touched on this with lease options. But let's talk about the advantages and disadvantages of acquiring property subject to existing loans using different structures, starting with, wrap financing. What are the advantages and disadvantages of wrap financing?
Well, a wrap, when you're buying, is a subject to, whereas a straight subject to, the seller just deeds it over to you and the seller's SOL if you don't pay his loan. He has no recourse. It's like husband and wife in a divorce. They do it every day of the week, where husband deeds his property to wife under a divorce settlement, and then the wife says, I'll pay it off within 2 years, and then after 6 months stops paying. The husband's out of luck, and his name's mortgage loan.
Yeah, and we've seen that, and that's a little bit of an aside, and we should have a whole show on that because, in my opinion, the problem that is created is at the court level with the attorneys, the family law attorneys that don't appreciate or understand real estate, and they're not bringing in a real estate attorney who can put provisions in the decree or create, instruments that allow for that possessing and non-titled owner to have some recourse if the spouse awarded the property is not paid. And because we've seen this on our end a number of times. We used to have a family law attorney, and he would see this over and over again, not from his clients, but from other, attorneys who then hire him because all of a sudden their credit's being ruined because the spouse that was supposed to pay isn't. That's a whole aside, but I'm with you. That would be a great show.
But taking subject to versus a wraparound is you take subject to, but you give the seller a note and second, called all-inclusive mortgage or trust deed. And the reason it's all-inclusive is it includes the underlying mortgage. So if the underlying mortgage is 100 and you wrap 100 around it, there's not 200 in liens. The 100 second includes the 100 first.
Exactly.
There's only 100 in liens. That's why we call it all-inclusive. But basically, it's a second lien. So if the buyer doesn't pay, the seller can foreclose and get the property back. In the meantime, he's got to make the payments on the underlying loan to preserve his credit while he's foreclosing. So that's, in a sense, it's a little fairer for sellers compared to a subject to. Usually I'm representing buyers on those, so fairness to the seller is not my primary concern. But, I don't want to overreach, but, some attorneys will say you should always do that because judges will view it poorly if you don't. And I haven't had that experience, but there's a particular problem with that in Colorado, why I advise against that. And the reason is to release a deed of trust in Colorado, we don't have private trustees. We have a county official called a public trustee in every county. So they're the trustee of the deed of trust. They require the original note marked paid to release. They'll give it back to you, but you have to mail it in physically or post a bond, which is really expensive to get if you've lost it. So now you took subject to from someone, gave them a second wrap, and 5 years later, you can't find the person, or that you found them and they can't find the original note. You see the challenge here. So that's a more likely scenario than the buyer defaulting and seller wanting to foreclose. So in Colorado, I just say I advise against it if you're a buyer. But in most states, I have really no problem with the all-inclusive trustee. Now, if you're buying that way, that's fine. But if you're selling that way, people prefer to buy subject to sell on a contract for deed in most states.
And why is that?
Well, for the main reason is especially if you don't record it, and most states don't require recording, only a few do. It's like a lease. You just evict them, or you do what's called a forfeiture proceeding, which is shorter than a foreclosure. In some states like Florida, you have to foreclose. I think Arizona, you have to foreclose too, right? In a contract.
Well, in Arizona, you have to do a notice of forfeiture, and then, but you can either do it non-judicially or judicially, but the only way you can do it non-judicially is if you've put a servicer in place to collect the payments. If you don't have a licensed servicer, then you have to go the judicial forfeiture route, which is more time consuming and costly.
Yes. So the reason why we like to sell on contract for deed is that, the old expression, possession is 9/10 of the law.
Right.
If I have the deed and you don't, I'm in a better, stronger legal position if you default, because in my state, we don't have a forfeiture statute. So what we do is we just proceed with a holdover eviction. And if the buyer shows up in landlord-tenant court and says, wait a minute, this isn't a lease, this is a contract for deed, they bounce it up to the regular district court. And in about 2 months, you'll get a hearing on it, and the judge will decide, is it fair to let the eviction proceed, or do you have to foreclose them? And in my experience, 98% of the time, the judge bounces it right back to landlord-tenant court and lets the thing go through. Unless there's a substantial amount of equity in the property, we're able to do that. And in my experience too, having closed probably 1,500 contract for deed sales for clients in the last 25 years. Most people who default just get up and leave.
Yeah.
And if not, they can be bought out, bluffed out with a 3-day notice on their door of non-payment. Or, you file the holdover eviction and they don't show up. It's very rare that someone raises this argument because, as a practical matter, if they can't afford to pay you, where can they get enough money to afford an attorney to fight it?
Well, so I mean, if Arizona had that statutory scheme where all you have to do is an eviction, a holdover eviction on an agreement for sale, we'd see a lot more dispositions using agreements for sale. But here, actually, if the principal is paid down enough, you have to wait. I believe, Andy, is it 9 months? Maybe.
Yeah, it's 9 months. It goes from what the shortest period, like 30 days, I think. But then goes as high as I think it's 9 months.
Indiana has a similar law. If there's so much paid down on it, then you must foreclose. Otherwise, it's a forfeiture, not a foreclosure. And for those watching, a forfeiture is like a little longer than an eviction, but a lot less than a foreclosure.
It can be, depending on how much principal, at least here in Arizona, how much principal.
And again, the way people worry about this, and I say, look, especially in my state where it's an equitable argument. So the judge says, do you have equity? So if there's 100,000 in equity in the property to fight over, it's worth the fight to hire a lawyer and foreclose them. If there's only 20 in equity, it's not worth the fight, but the judge is likely going to say, you have no equity, proceed with the eviction. Right. So, if someone's worried about, if they have all this equity and they claim this claim that we have to be foreclosed, if you've got a couple of 100,000 in equity, they've built a garage and the property's gone up in value, it's worth the fight. So don't worry about it, But that's and the other thing with contract for deeds that I like is again, I said earlier, most states don't require recording of the actual contract with the county. Ohio, I know, requires it, and a couple other states do. So if you don't record it and they just leave in the middle of the night, you don't have to do a quiet title.
Right. But now the downside to that is, although I don't think that, once again, you're representing the investor. So,
right.
But
if I've
from
heard a buyer, I'm going, no, here's a place to notarize it.
Yeah. From a consumer buyer, you're like, well,
yeah.
What's stopping this investor from, selling the property, pulling equity out,
Right.
refinancing, whatever. And that's the downside with not recording
Right.
is
Right.
you're
And
providing
that's
that
what client, the seller wants all these.
Yeah, right.
People watching, you got to realize we're attorneys. We're not mediators. So when we represent a buyer or a seller, we're concerned about our client's position. We're going to assume that they're the good guy and do the right thing. And therefore we're going to put clauses and provisions and do things to, slant it towards our client. Where we're representing the other party, we would do the opposite. Some people ask me like, well, do you have like a middle ground contract that's kind of fair to both sides? Like, no, because I don't represent multiple parties in a transaction like that. It's unethical. You can't, and I say you can't, but it's rare that I would do that because seller and buyer have competing interests, and they can't really waive their competing interests unless it's like father and son, maybe, or something like that.
Right. We're not real estate agents with, the ability to do due agency. And I mean, we have to represent one side over the other. If not, we have to have, buku disclosures and, full, no confidentiality whatsoever.
Right.
Right.
Right. Yeah. So, generally I like to buy subject to, sell contract for deed, with the exception of Texas where you can't really do that. But even in a state like Florida, where they consider contracts for deed mortgages and you have to foreclose them all, as a practical matter, possession is 9/10 of the law.
Yeah.
If you have the deed and they have a contract which is not recorded and they're in default, you have leverage. Mm-hmm. So you can say to them, listen, you put $20,000 down, I'll give you $5,000 back if you sign this, waiver and release of your interest in the property and the possessory rights, and be out by next Friday, and I'll give you $5,000 and we'll call it a day.
Right. Yeah. Well, you've already touched on this, but let's talk about, whether or not and when, if any time a investor may want to acquire a property with a lease with an option to purchase. I have a few ideas that, I've seen work, but I'm curious to get your thoughts on when that might work for an investor on an acquisition,
Right. And I've done that as an investor myself many times, especially early in my investing career. Because when you're approaching a seller who's not behind in payments, not really, strongly motivated, just somewhat motivated, and you say, why don't you just deed me over the property? They go, out. They give you the Ralph Cramden, out. Throw you out of their house. Think you're crazy. So you got to kind of, make a judgment call. Do I go for the gusto and get that deed, ask for the deed, or do I do something soft like a lease option, which most consider as a lease, not a real purchase? So then I'm inclined to run to attorneys or brokers. They're a lot easier to negotiate. They're softer for the seller. So if the seller was current on his payments, had plenty of equity, had a good job, and was concerned about his credit, I'd say the chances are pretty good that everything's going to be okay. And I would, in that situation, lease option it from the owner. I'd rather get the deed, but if he's got $100,000 in equity and he's not behind in payments and he's got a 750 FICO, he's probably not going to do that.
Right. Yeah, I've seen it used successfully too. Back to the divorce scenario where one spouse has already been awarded, or they've agreed, entered into a settlement where one spouse was going to receive title and possession of the property, but the decree hasn't been entered because they're fighting about child custody or child support or whatever. And so you don't have a final decree. You don't have, title, but that spouse is wanting to move or unload the property or whatever. So, you could go in and do a lease with option to purchase, waiting for them to finalize the divorce, get the decree, convey title, that type of thing. Those are times when you might want to do that. Or, there are due on sale clauses that don't prohibit leases and or options. Fannie Mae, Freddie Mac generally will, FHA will, but there's some private lenders, some credit unions, other people who have their own portfolio loans. And when you read the due on sale clause, you're like, oh, I can lease this thing for a long period of time and not violate the due on sale.
Right, right.
So you have a seller that's concerned about that. Why not do the lease option, take over, their payments or whatever, and just lease it.
Oddly enough, it's in my experience as an investor, both as an attorney and done a lot of transactions with people, very few sellers bring that up or even realize that due on sale is an issue. They just think you're not allowed to transfer title outright. And those who are watching, I mean, there's like 6 other transactions that trigger a due on sale: a land contract, a lease option, a lease of more than 3 years. I mean, there's so many other things that do. But since title doesn't transfer at the courthouse, most servicers are not paying attention to this unless they get a change of insurance notice that says, oh, there's this new person who's the insured because they changed subject to title. Where you do a lease option, the lender's clueless about it.
Yeah. Let's talk a little bit about some, non-traditional structures or methods for doing subject to either acquisitions or dispositions. One is utilizing a land trust and swapping out, trustees, beneficiaries, that type of thing. And I know you're familiar with that. Talk to us about how you could, utilize a land trust to accomplish a subject to.
So one of the exceptions under federal law for a borrower who has a due on sale mortgage is to put it in usually his estate planning living trust. Right. But it just says revocable living trust. It doesn't say revocable. It just says living trust. It can be revocable or irrevocable. And that's an exemption where if I own my property and I want to do some estate planning, I could put it in my living trust with me as the grantor beneficiary, and the lender cannot invoke the due on sale under federal law. That's in residential properties, not commercial.
Right.
So what people do is they put it into a land trust, which is a type of revocable trust, living trust. And it's only for one property. It's not like, Joseph E. Smith Living Trust. It's 221 Main Street Trust. And then the grantor and beneficiary of that trust is the seller, step 1. Step 2, we deed the property to that trust and record it. Step 3, we assign his interest in the trust, his beneficial interest, to us as the buyer. And then the seller resigns as the trustee, and now we appoint someone who's a trustee. And the point of that, and I used to do this a lot in the beginning, like my first 10 years of doing this, was, if the lender saw this and saw the change of insurance notice or saw the change of deed transfer, would assume the seller's doing some estate planning and not make a stink. And then I discovered after about 10 years that lenders just don't really care.
I think that's where we're at now.
Because the interest rates on the loan are not like, 8 or 10 points below market rates, they don't have an incentive to pull in loans.
Right.
Plus, we're not dealing with, this was in the early 80s when you had savings and loans, small little operations who were servicing their own stuff, and they knew what was going on. Now we've got third-party servicers, Citicorp, Wells Fargo, Bank of America. They're not paying attention to this stuff, and they really don't care.
Right.
If interest rates went up to 12, they probably would start policing this a little more. I don't even think like taking over a 3% loan and market rates are 7 is enough. I don't think 4 points is enough for them to make the stink.
Well, yeah, to your point, I mean, you have these servicers who, Andy and I know this from the short sale days, like they have this box and they basically give their employees a script. And if it doesn't fall within the script, it's like, oh, I don't know, we can't do it, type of thing. And, the insurance person collecting the insurance certificates is simply looking to see, is the property insured? They're not looking to see by who or otherwise, right? It's like, I get paid X amount of dollars an hour to process these insurance certificates as they come in.
Sometimes you'll get a letter that says, wait a minute, because when you transfer the property from seller to buyer subject to, the buyer or his LLC or whatever, his trust or however he's doing it, is now the named insured. And then the copy of this goes to the lender. Now, some lenders will say, wait a minute, the borrower is not on the policy. The borrower has to be named on the policy. So I'll call up the insurance agent and just say, can we put the seller on as an additional insured, which doesn't give him a right to a check. It just gives him a right to be
Right.
protected if in the case of a lawsuit. And usually that does the trick. Once in
Yeah.
a while, we get a
Right.
lender
Yeah.
who says, no, we want the borrower to be a named party to the insurance, which means if there's a loss, now I have to take my check that's payable to me or my LLC and the former owner and get a signature from him.
Right. That's
And he
going to be
might
pain.
say, how much do I get out of that?
Right. That's going to be a real mess. Or you pay for double insurance, the
Yeah.
buyer gets their own
Yeah,
policy.
that's so you keep the existing insurance in place, which is still covering the lender as the lien holder, void as to the seller and buyer, because the seller no longer owns the property and the buyer is not a party to the contract. Buy a second policy naming just the buyer as the insured and don't send a copy to the lender. And now it's bulletproof. The problem with that is in the state of Florida, that's like an extra $4,000 a year. It's different in other states where it's $1,100 a year, I can handle that. But in states like Florida, where the risk is very high of loss, a cheapy little property could be $4,000 a year, and that's just not doable.
Right. Exactly. Yeah.
But it's a good point. The double insurance thing is sometimes a good idea.
Yeah. I mean, I'm with you. I would avoid it if possible, but if need be, you got to make sure you're protected and, you're not stuck fighting with the seller's insurance company to get money,
Right.
So last question from my end. And then I think we have some questions from the audience, but talk to us a little bit about, and I've, seen this done in a few circumstances, utilizing membership, conveyance of membership interests in LLCs in order to buy and sell property subject to existing loans.
Yes.
How would that work?
Similar to a land trust, we create an LLC. The seller is the member and the manager, and then he assigns his membership interest in the LLC to you or your LLC. Resigns as manager, you're the new manager. I've done this a lot in the commercial context, multifamily specifically, where the seller already had it in an LLC that only owned that property and never did anything else, and took the loan out in the name of the LLC, and he's the manager and member. And we just sold his membership interest from himself to my company now as the member of that LLC. I did one particular one, which was really complex. The only time that doesn't work is if the lender that the seller took out with his lender requires an annual audit of his financials. He had to report that as a sale. And what happened to your property? It's not on your tax return.
Right.
So that doesn't work there. But usually smaller commercial properties, they don't require that. But I did one where it said you couldn't change the manager or add a manager, and you couldn't transfer more than 25% of the membership. So me and the seller's attorney went, well, let's just draft exactly that.
Right.
We did an agreement where they transferred 25% with an option to buy out the other 75 for $1.
Yeah.
And then instead of changing, we left them on as manager and added officers, president, secretary, treasurer, who had more authority than he had as manager.
Well, that's brilliant. And even more interesting is, depending on the taxation component of the LLC, you can have somebody who owns 75% interest, but gets 0% of the distribution. You can
actually, that's true. But we got a CPA opinion from a big firm that said, no, that's really just a full sale. It's a disguised, version of a buyout, was a joke. And then they said you could report this as if, the property's all yours.
Yeah, I see.
So we have that in our back pocket to protect us.
Yeah. Interesting. Well, that's yeah. I mean, there's, and there are some, a lot of people think, oh, when we talk about the due on sale clause, we think that there's this one clause that exists out there that everybody has to, be careful of. Each loan and deed of trust and mortgage is going to have its own separate due on sale clause. And some due on sale clauses are going to prohibit the conveyance of, the ownership interest of an entity. and others are going to be silent, and you perfectly, you are allowed to do that to the fullest extent, and there's no issue there.
Right.
So you have to look at the due on sale clause every time that you're doing one of these transactions.
Right.
And even Fannie Mae, Freddie Mac, they're pretty much uniform, but
Mhm.
there are some older due on sale clauses that are not the same as the due on sale clause we see today. So, when you're doing this, and if you have concerns of the due on sale clause, you need to, make sure 100% to review that due on sale clause, see what it says, and figure out what you need to do to avoid it if possible.
True, especially in the commercial realm.
Yes,
There's a few
absolutely.
standards, Fannie, Freddie, and FHA
Right.
a little bit.
Yeah.
But most small, like commercial banks, they have their own paper.
Right. Exactly. Yeah.
So you got to read it.
All right, Andy, we have some questions.
Yeah, we got a few questions, so let's get into those. So the first question is from a Facebook user. The question is, how do you handle sub 2/wraps when the underlying loan is FHA?
Just like any other loan. Some people are under the mistaken delusion that you can't take a subject to on an FHA because it's federally insured, which makes it a crime. There's no law that says that. It's not a government loan, it's a government insured loan.
Mm-hmm.
So it's a regular bank lending the money. And it's up to them whether they want to call it. And a lot of times they don't want to call it because FHA doesn't insure 100% of that loan. So it's a tough judgment call. Now, the only thing I have to warn people is some state-sponsored programs, low-income programs, will lend the borrower the 3.5% down and take a second on the property. And there'll be two mortgages against the property, FHA, and then the state-sponsored thing for the 3.5%. They will universally call that loan due in a second if the borrower even moves out.
Mm-hmm.
So you have to pay off that second.
Right.
So when you see that, in my state, it's called the Colorado Housing and Finance Authority, or CHAFA. So if you see one of those, you see a second, and it looks like a state-sponsored, loan program, take a look at that deed of trust or mortgage.
All right, another question. Most asked question from sellers, this is from a Facebook user, but the most asked questions that they get is, quote, show me where it says buyer is going to make payments on your contract.
But I guess you have to have that in your agreement. You could say that as long as you're not personally the buyer, you're personally obligating yourself to the seller. You're implicitly, you are. Even if it doesn't say that, I could make a good argument as the seller's attorney. If you don't pay, I could sue you personally for not making the payments on my loan. But if the seller asks, like, where does it say you're paying my loan? If it's a subject to, just put a line in there in the contract that says, I promise to pay your loan starting this date, but you're not making the promise, your LLC is.
Right. And that's where it gets back to what you were talking about, Bill, which is, don't be penny wise and pound foolish.
Right.
If you're using a contract that is not designed for a subject to transaction, you should probably go see an attorney.
Right.
In the state that you're doing transactions and get
real quick about
wrapped
that. This is what I'm seeing a lot now from these instant gurus. The seller puts a deed the buyer puts a quit claim deed in escrow with a title company. And if the buyer misses 2 payments, the escrow company can give the quit claim deed to the seller that they can record and get the property back. I see you shaking your head. I don't know of any state in this country where that's legal. You can't. Equity abhors a forfeiture. That's the expression we learned in law school. So you can't basically circumvent a foreclosure process by putting a deed in escrow, whether it's a loan, a subject to, or whatever, that automatically transfers the property back without any.
Yeah,
your co-tenants. It's your joint tenants, and they shoot you.
We had a lengthy discussion about this in one of our creative finance collectives, and there was universal agreement from lawyers in every other state that was represented that there is no circumstance where that's a good idea.
Right. And now, if you don't fight it as the buyer, if I just don't fight it, then there's no problem. Well, I think you're misrepresenting what it is as the buyer if you're putting that in the contract.
Yeah, and to your point, I've kind of gone back and forth on that whole argument myself, like in my own head. If you're the buyer and you can't fight it, I get that. But here's my concern is, what about this circumstance where I, as the buyer, go and give you this deed and say, hey, look, you're all good. If I don't pay in the next, if I don't pay for 2 months or 30 days or whatever, you just record this deed and it's all taken care of. Well, what happens when that buyer goes in and does work on the property and there's mechanics liens, or the buyer gets a judgment against them that gets recorded, or the buyer, gets in trouble with the IRS, or whatever the case may be, and you have these liens against the property and the seller's like, great, they record the quitclaim deed. Oh, guess what? You take it subject to all these other obligations that
Right.
you
Quitclaim deed is no guarantee of title, right?
Exactly. Yeah. And so, to me, if you're going to do that, you better give a lot of disclosures saying, hey, this is what this means. You better get title insurance. You better run a title report. You better do this. And I know for a fact those disclosures are not being made, right? I mean, that's the problem.
Back to our first point, isn't it? About using a qualified attorney in your state to help you with your first few transactions at a minimum.
Correct. Yeah, exactly. But I'm with you, Bill. I think that your contract, even if you're doing a straight subject to, which I personally am not a big fan of, I like the wrap. If you do a wrap, then it's in the contract, right? It says, oh yeah, I'm going to give you a note that's going to say I'm going to perform, like, basic. But if you're doing a straight subject to, you should drop a line into that purchase contract that says that I will pay your mortgage payment starting on this date and every month thereafter.
Mm-hmm.
Yeah.
Another question from a Facebook listener. Would you keep, this is a lease option question. So, or would you keep insurance in the seller's name in a lease option?
As long as I'm added as an additional insured, as to not additional insured for liability, but I want to be additional insured for liability, but I want insurance to be amended to insure my option or my interest in the property to the extent it exists. The reality is most lease options don't have a lot of equity. They're cash flow devices.
Right.
So in the unlikely event that it burns down, I guess your subtenant is out of luck. It's a judgment call how much equity is in the property. Really. Yeah. That's what it is. But I'm okay with amending the policy, or even getting like an additional policy, just like you said, just ensuring my interest.
Right. Yeah, and remember, on a lease option, you as the investor are leasing the property, and so the insurance should remain in the owner's name. It's not even the seller's name, right? It's the optionor and the lessor. Right. It should remain in their name, and then you can be added as an additional insured, or like you said, get your separate policy. But a lease option is really, it's not really, in my view, a subject to transaction, in the sense that it's a commercial transaction. It's a lease with an option to buy. So things are going to be a little bit different and structured different using a lease,
right,
with an option. Yeah.
All right. Well, we are coming up on an hour, and Bill, I know you're a busy guy, and we're so happy that you took the time to be with us. Why don't you tell our listeners how they can find with you and connect with you?
Great. Thank you. If you are outside of Colorado, I have lots of online courses, videos, articles, and things at legalwiz.com. If you're inside of Colorado, you can't use my forms. You have to hire me. I'm just kidding. If you're in Colorado, you want to hire me, it's bronchicklaw.com, or you can go to legalwiz.com and at least learn what to do before you pay me by the hour to teach you what you're doing wrong. And then I also have a YouTube channel, YouTube.com/Bronchick. And probably have 110 videos on there on different categorized topics, and a lot on creative finance.
All right. Yeah. Thank you for that, Bill. And for our listeners, if you go to our INREM channel, we have Bill listed as one of our recommended channels. That'll take you right to his YouTube page, so you can find him there as well. But Bill, thanks so much for being with us. We look forward to doing it with you again.
Thank you. My pleasure, guys.
All right. Have a good one. With that, everybody, that is our show. Make sure to join us next week. Make sure to join us tomorrow evening for the Creative Finance Collective. Another good opportunity to ask questions. We'll see you all next week.
Have a good day, everyone.